The vindication for me and my favorite part and why I share your enthusiasm is because for the last two, and I don't know how many years we've been doing this podcast now, I always start out by saying, coming to you from Studio 3553. And the reason is because that has been, the beating heart and soul of this practice to say, forget the guidelines, 3553 is everything.
Yep.
And for them to now say, the court must consider the widest possible breadth of information about a defendant, ensuring that the court is in possession of the fullest information possible concerning the defendant's life and characteristics. That's all the soft stuff that everyone,
Yeah.
you know, good-naturedly pokes at me for. But the soft stuff is the beating heart of what we're doing. And it says, Judge, these are human beings, and you have to have every single piece of information about this person's life in order to make a fair determination about what their sentence should be. And now it's just there in big, bold, black and white letters.
Over 1 million Americans face sentencing every year, and it will be the most important day of their lives. But we don't fully understand the system, how broken it is, and what we can do to make it better. I'm Doug Passon. I'm a 25-year criminal defense lawyer and a sentencing expert. My goal is to bring more awareness, more fairness, and more humanity to the sentencing process. So, are you ready? Then let's get set for sentencing.
Hey everybody, Doug Passon coming to you playing the home version today, not at Studio 3553, but still from Scottsdale, Arizona. Welcome back to Set for Sentencing, and of course, welcome back my dear friend and colleague and guidelines guru extraordinaire, etc., Mark Allenbaugh. Hi, Mark. Welcome.
Hey, Doug. How are
How's it
you?
going?
Well, you're talking to me from Western Gilead, and I'm saying hello from Eastern Gilead.
Yeah,
So,
because we're recording this on Monday. What a way to start the week, Monday, for April
yeah.
14th, 2025.
Yeah.
And we both were just commenting on the news alerts that came through on our little devices that said El Salvador says ain't giving back this prisoner who's being held for no crime in a horrible, horrible jail in El Salvador. And Trump's apparently saying, Supreme Court, I don't care what you say, I'm not doing it. What does that portend for us? I mean, it's not what we're talking about today. We're actually talking about some major, ridiculously major changes to the guidelines that are up
Yes.
to a complete certainty. But this, you can't help but recognize that we have a serious constitutional crisis. It's not coming. It's just full on here. Once a president says, right? Once a president says, Supreme Court, I know what you said. I know what your
Yeah.
ruling is. I know you're supposedly an equal, co-equal, a part of our tripartite government structure, but I don't give a fuck. You're there. You're in a full-blown constitutional crisis. Am I overreacting to that?
No, because even the Supreme Court I think this was on Friday, when it affirmed the district court's order to return, this gentleman said that the government has to facilitate his release from custody in El Salvador and to ensure that his case is handled and that he comes back. And the court or the government has to effectuate his return. And now Trump's just using actually the president of El Salvador, who happens to be here, to flip the bird at the Supreme Court. Nah, I ain't going to do it.
And who, by the way, is profiting off of these prisoners? They're getting paid millions of dollars to take these prisoners. But
Yeah.
I'm glad we're talking about it, even though this is not the topic of the day, because this is the most offensive thing of all the offensive things that have happened over the course of the first term and now. I think this is by far off the charts the worst when you think about this. First of all, there is no need to send anybody, even if they are here without proper documentation, even if they do have a criminal past, even if they are gang affiliated, there is no need to ship anyone to fucking El Salvador to languish in
Yeah.
prison. We have a process in place. We have immigration courts. If they're not here lawfully, I mean, this has been happening for the 2 decades I've been working in federal court and handling immigration prosecutions, criminal matters. If you're not here legally, you're on the next fucking bus back to wherever it is that you came from.
Yeah. Yep.
And if you are not here legally and you came back, you're looking at some degree of time, federal time, for a crime called illegal reentry after deportation under 1326. So we have courts, we have a judicial process in place, we have
Mm.
punishments, and we have ways to get rid of people quickly if we need to through deportation. But for some odd reason, this administration has said we're going to round you up, give you no due process, no hearing, and ship you to a country you may not even be a citizen of, and put you
Yes.
in one of the notoriously worst, maximum security, violent, gang-infested prisons in the history of the world to rot, and there's not a fucking thing you can do about it. You're not going to be able to see your family. You're not going to be able to talk to a lawyer. You're never going to
Mm-mm.
have a hearing. And guess what? You may never get out of that place. What
Well,
is
this
what
is
is
just
even the mechanism to get out
yeah,
of there?
right. Well, this is just like what happened in Argentina and Chile, but really Argentina during the 70s, where they started disappearing a bunch of political prisoners. And that's the next step here. And there's no reason why, what's going to happen if a US citizen gets dragged into this and he's down there and the government is not willing to repatriate him,
Right.
which is exactly what. So
And
this,
it's
I
easy.
think this is kind of a test
For all
case.
we know, there are U.S. citizens. I mean,
Exactly.
this gentleman, Abrego, what is his name? Garcia-Abrego. I,
Yeah,
I
he's
want to
never
know.
been criminally charged in the US or in El Salvador,
He was here
ever.
lawfully, even though
Yep.
he's not a citizen. He had permission from our government to be here, and he was plucked off the streets, given no hearing. They said he had some gang tattoos, and therefore he was a gang member, and he's not. He's
Yeah.
absolutely not. And you're absolutely right. If they can do this to him, they can do it to anyone. And guess what? That is the point. That is the point the administration is trying to make. I know this is wrong. I know he's probably didn't do anything, but guess what? I can get away with it. And this is not just a message to anyone who's here unlawfully or without proper documentation. It's a message to anyone because political dissidents will be next on this list. You fucking mark my words. And apparently nothing that can be done about it. And last time we talked about this, we talked about Timothy Snyder and on tyranny
Yeah.
and invoked
Yeah.
the lesson there about the overuse of the word terrorism and this kind of language branding. We talked about branding people as terrorists. Well, guess what? The number one lesson is from on tyranny. Do not obey in advance.
Right.
It says much of the power of authoritarianism is freely given. In times like these, individuals think ahead about what a more repressive government will want and then start to do it without being asked. You've already done this, haven't you? Stop. Anticipatory obedience teaches authorities what is possible and accelerates injustice. So that if
Yeah.
they can get by with this, which seems clearly they can, then they're testing the limits of what their limits are, and there are none. And this
Right.
this should be the most terrifying thing of all of them, in my opinion. So, I don't know I think that, what do you what's the action item? Call your representatives? I don't know if that's going to do
Well,
it.
the action item is to
Protest,
peacefully protest. Yes,
take to the
and
streets.
April 19th, this coming Saturday, there's going to be, another nationwide, there's going to be protests going on nationwide
Yeah.
against what the Trump administration is doing. And I'm not even sure if we call it the Trump administration anymore because they're not administering the law.
Yeah.
They're not executing the law. It is just a gang of increasingly looking like
Thugs,
a gang of thugs. Yeah,
violent authoritarian thugs,
right.
brown shirt
It's
thugs.
right. It's we are. It's starting to feel like we're in occupied territory.
Well, I went to the first rally, the Hands Off rally in Phoenix. It was a great turnout, and I'm hoping that it's much, much bigger now. And if I had my way, the whole rally would just be about this one man and his struggle.
Well,
Because
since Doug, since we're talking about liberty and the lack, excuse me, the lack of due process or the absence of it. Well, yeah, same thing, I guess. I think this would be a good segue to talk about something called supervised release and what the commission just did.
yeah.
You know,
All right. Well, that is a good segue. So we are
yeah,
gonna let's talk about this because we have there's some we had talked about the fact we did another podcast about that the commission was considering this, but last week they passed these, so this is
yeah,
happening. And as
yes.
usual, we just are in a waiting period until November 1st to see whether Congress acts or doesn't act, and they almost never act, and these become enacted guidelines changes
Mhm.
on November 1. So this is, you mentioned last time, like how many times have these ever not gone through? Like never,
Yeah,
right?
three times out of
Yeah.
830 something amendments to the guidelines in 40 years.
Yeah.
They've only been rejected by Congress three times.
And so we're going to talk about huge, huge, huge seismic shift in the guidelines. The supervised release, I wouldn't say is the biggie, but it's a good place to start. And before we
Yeah.
do, if I would just say, like, normally I'd be wanting to be drinking, but it's only 11:40 in the morning on Monday, so I'm definitely not drinking. But if I were drinking, I picked out the bottle that I would have. It's called Lost Lore, and this is the best I could do for a tie-in, but the guidelines just lost some significant
Yeah.
portions. Like this was beyond a circumcision. This was like removing, I don't know, both testicles or something. There's a whole lot of stuff that's about to be dropped out of the guidelines. So I think, when it becomes 5 o'clock and I have a little sip of something special, it's going to be lost lore. Very nice. Okay, so let's talk about supervised release. For people who probably already know this, you get a sentence in federal court to prison, and that almost always includes a term of supervision to follow. It's very much like probation. It's called supervised release, where you have a probation officer from the probation department supervising you much the same way that it would on probation. And I would say more than 99% of the time in our federal cases, clients are getting a term of supervised release, anywhere typically from 1 to 3 years, but statutorily there are some crimes where it could be more, and some
Yeah.
cases it could be up to life.
Life.
So
Yeah.
what changes are coming down the pike November 1 officially?
Well, they look like good. So going back to that, so, just to give a little background on supervised release, as you were saying, it kind of looks like probation. The purpose of supervised release is to help the inmate transition back into the community. There are a lot of restrictions on the inmate. So once they are released from prison, they can go home, but they're still restricted in where they can travel and when they can travel. Some of them will have restrictions on where they can work, what kind of even electronic devices may be allowed in the home. Uh, Sex offenders generally are precluded from having any type of access to the internet or even cell phones, smartphones. They have to use like flip phones or phones that do not have access to the internet. So there are, the point is, there are a lot of restrictions. As of last year, 82% of cases of all the 60, there were 61,678 people sentenced under the guidelines last year, and 82.5% received a term of supervised release.
Hmm.
The average term was 47 months, almost 4 years,
Yeah.
and the median was fully 3 years. And that varied a lot. It really depends on the type of offense that gets supervised release. You see them most frequently imposed, like child pornography cases, 99.3% received a term of supervised release there, which can be up to life.
Yeah.
Drug trafficking, which was the second largest group of offenders last year, 94.8% received a term of supervised release. Surprisingly, in immigration cases, even though supervised release right now and historically has not been required for foreign nationals, 69.5% were still getting a term of supervised release for some reason, because generally once they're out of prison, they're handed over to ICE custody. and they generally have a hearing before they're deported somewhere, but
Yeah.
that might be changing
Well, and I
here.
will say, in handling, it was because I'm in a border state, and in
Yeah,
handling a lot of those immigration cases, it's very intentional because they want to have an extra hammer in case the person is deported and then returns again. Because not only did they get charged with a new crime of reentry under 1326, but they get charged with a supervised release violation. They can be given extra time for that, and they can be run consecutively. So it's a way to hang that extra hammer. But one of the reasons, correct me if I'm wrong, but that the 86% number is that what it is, it's so high, is because under the existing guidelines,
yeah,
the judge has no discretion if the sentence that the judge is imposing in prison is a year or more or greater than 1 year.
yeah,
There was no discretion that she has to also give supervised release, no choice. And then, of
right,
course, there's a few cases where they're statutory obligated,
right. Well,
but
it's required.
you could tell me the stats, but I'm
Yeah,
sure that more than 86% of all sentences imposed are over a year in
yes,
prison. So that's why there's such a high thing. So
yeah,
first big change is that one, right?
right. So now judges do not need to impose a term of supervised release on somebody that's been convicted of a felony where they've been sentenced to more than a year in prison, in which you could be convicted of a felony and not be sentenced to that period of time. But the point simply is, if you're sentenced to more than a year now, a judge is no longer required by the guidelines to impose a term of supervised release, which is significant and quite helpful. I mean, first of all, puts a lot of strain on the courts, puts a lot of strain on the probation officers as it is to just automatically impose a term of supervised release. A lot of these inmates aren't going to, or these former offenders,
Yeah.
the chances of them recidivating are extremely low.
Yeah.
There's really no purpose associated with supervised release. They're already educated, or they have a job lined up, or something along those lines, where the need for supervision is really non-existent. So,
Yeah.
the rubber stamp of supervised release all the time. I'm glad that the commission has finally recognized that
Yeah.
that's not always necessary.
They
And
actually say in their synopsis, the framework aims to, quote, assure that those who will need
right,
post-release supervision will receive it while, quote, preventing probation system resources from being wasted on supervisory services for releasees who do not need them.
right,
So the question
right,
is, who needs them? But
right.
before we get to that, I want to say, be careful what you wish for, because the hero in me as a defense lawyer is saying, great, this gives me all the ammunition I need to convince a judge not to impose supervised release because nobody wants supervised release.
Yeah.
But you need to be aware that there's a pretty significant ramification for not getting supervised release, and it has to do with the First Step Act and the credits, early earn time credits that somebody can earn while in the Bureau of Prisons.
Which, by the way, Doug, I do note that the commission did add application note 7 to 5D 1.1. 5D 1.1 covers the imposition of a term of supervised release, and new application note 7 does discuss First Step Act credits.
And okay, good. Because
It,
what does it say? Because
and
my
it says,
fear, what I was told before this amendment, which is true, is that if you don't have supervised release, you're not earning your full credits. Be
it says whether a defendant's sentence includes a term of supervised release may impact the application of time credits earned by the
oh,
defendant
so it doesn't fix
under
it, it just warns you.
under the First Step Act. So it's
Oh,
warning you here.
yeah.
And it says the First Step Act allows individuals in custody who successfully complete evidence-based recidivism reduction programming to earn time credits. Regarding the application of those time credits, the First Step Act provides if the sentencing court included as a part of the prisoner's sentence requirement that the prisoner be placed on a term of supervised release, the BOP may transfer the prisoner to begin any such term of supervised release at an earlier date, not to exceed 12 months. Okay. But they don't say, okay, they don't go on. That's just basically where the application note ends. But the implication is that if you don't get supervised release, then anytime you're not going to be able to earn any time credits under the First Step Act for earlier transition out of prison. Because the whole point of the First Step Act, of these recidivism reduction time credits, as the commission is referring to them here, is to reduce your time in prison and get you onto supervised release earlier than what you otherwise would have received. But what the commission is saying here is, be careful, as you said, be careful what you wish for, because if you don't get any supervised release, you're not going to be eligible for any time credits. So what's the moral of the story here? Well, I think the moral of the story is the same thing why defendants don't want to ever be sentenced to 12 months. They want to be sentenced to 12 months in a day, because anything less than that, you don't get the 15% good time credit reduction. Well, here, you're going to probably always want to have at least 1 year of supervised release ordered, so that way your client or you could earn time credits.
Yes. Yes. And there's an interesting little new provision here too, which I read to basically say, so the court always has the authority to terminate supervised release early, or even extend it if something's going wrong and there's more time. You didn't get the full amount of time. Court has always had some discretion to tinker with it.
Yes.
But the relevant, just sticking with this, okay, ask for the year. Well, there's something in here that says, addressing the court's authority, it says it encourages the court, in consultation with the probation officer, to conduct an individualized assessment to determine whether it's warranted to modify, reduce, or enlarge the conditions of supervised release after a defendant's release from imprisonment. So the way I read that is, supervised release is given at sentencing, and then you get out and you start serving it. And if things are going well after, a year or something like that, you can ask to. No, this says, the way I read this, it says the day you walk out of the Bureau of Prisons, you can go back into court and have the court take another look at this. And so if you got a year, you could say, well, we asked for the year so we could earn our credits. And guess what? We earned all our credits because we had impeccable behavior, no disciplinary. I took this class, I got this rehabilitation, I've got this job waiting for me, I've got this nice home. I don't need supervised release. And ostensibly, under this language, you could get out and immediately petition the court to say, just get rid of that.
Yeah.
And the court has a full authority to do that now.
Yes.
Yeah. What else has changed?
So what else is big is sex offenders. So this is, I guess, kind of a little bit inside of baseball, and I won't bore everybody too much with this, but sex offenders always get, or generally get, not always, but they generally get lifetime terms of supervised release. And by sex offenders, that also includes those convicted of just child pornography possession. They also are classified as sex offenders. Right. The way the guidelines were written, and by the way, this was a fluke. This had to do with some inartful amendments to the guidelines 20 years ago, but sex offenders were accidentally, or the guidelines were drafted in such a way where it was an accident of drafting, where it appeared to courts when you read this that if somebody was convicted of a sex offense, they automatically had to get the statutory maximum of supervised release, which for sex offenders was life. The commission finally, thank you, has addressed this error in drafting and modification, all that stuff, and has deleted that. And that's significant because, as I was mentioning earlier, those convicted of child pornography offenses, and there's not a ton of them, but there's not an insignificant amount. Last year, out of the 61,000 defendants sentenced nationwide under the guidelines for all offenses, almost 1,400 of them were for child pornography offenses. 1,366 of them did get a term of supervised release, And the average term was 190 months and the median was 120 months. So
Mm.
not all of them are getting life, but they're
Yeah.
getting a ton.
Yeah.
And so now that has been eliminated. So at least courts know, or courts at least no longer should by default impose lifetime terms of supervised release. And that also makes sense because for those of you who are aware of the nuances that involve child pornography offenses, not all child pornography offenders need to be supervised for that period of time, as opposed, viewing, those that view and those that engage in contact offenses are two different types of people, or two different types of offenders. And perhaps those that engage in contact offenses may need a longer term of supervision, but they shouldn't be lumped in, or those that do not engage in contact offenses shouldn't be lumped in with those that do. So the point simply is, now courts can be a lot more nuanced and individualized in their approach to imposing at least that portion of the sentence.
Right.
And that's significant.
Yeah. Well, I think the last big change here is this says that anytime after the expiration of 1 year of supervised release, the court may terminate the remaining term of supervision and discharge the defendant if the court determines, following consultation with the government and the probation officer, the determination is warranted by the conduct of the defendant in the interest of justice. So this is a slight change. I don't know that this was ever a policy formal, but the sort of unwritten rule was you were never going to get early terminated from supervised release earlier than half time. So if you got, and the average term is 2 or 3 years. So if you got a 3-year term, you're talking about 18 months. So this is basically saying, no, after a year, you're all systems go. If you can make a showing that you've been good, you've satisfied your obligations and everything's hunky-dory, you get right off any year. So that matters for people who've got 3 years or more, I guess that's as much as I can say about that.
Well, the one thing I do want to note here is that the commission did add terminology also. This is the 5D 1.4, which has to do with extending the term of supervised release.
Mhm.
And I think it was a little the way it's written is a bit too, I could see it causing problems, especially in our post-legal environment. And the reason why is what
You're
it
saying
says
in the
is,
Gilead court.
so it states this: the court may at any time prior to the expiration or termination of a term of supervised release extend the term of supervised release if less than the maximum authorized term of supervised release was previously imposed, and the extension is warranted by an individualized assessment of the need for further supervision. So what does that mean? It means that, let's say that the statutory maximum for the defendant, the statutory maximum term supervised release was 5 years. The court imposed 3 years, but now halfway, 2 years into supervised release, the court gets wind of something. Now the court can extend up to another 2 years to that maximum of 5, the conditions of supervised release on this defendant. And the problem is where this kind of reeks of Gilead is in the portion of the guidelines now that it speaks about extending the term of supervised release does not mention anything about consulting the government or the probation officer. This is just kind of like the court going with its gut potentially. And obviously that can be problematic, because to terminate early, it says the court must consult with the government and the probation officer, but it doesn't have that same restriction or that requirement to consult with these other parties for purposes of extending the term of supervised release. And the other thing, while it does cite to the statute that concerns modifying and revoking supervised release, which is 18 USC 3583, while it does cite to that, it doesn't mention the crucial part in that, and that is a hearing that the defendant is, even if there's no revocation involved, just to extend the supervised release, the defendant is a hearing is required. But that part of the statute didn't make it into the guidelines. And some out there might be saying, well, it doesn't have to because guidelines are. Yes, it doesn't have to, but for consistency and completeness and to avoid confusion and to make the guidelines easier to apply, which is the next part we're going to be talking about, is the simplification process. The commission should include something as critical as that about having a hearing for purposes of due process. And the other problem with
thankfully the Constitution still exists, at least today.
Well, it only
due
exists,
process exists, and the rules of criminal procedure exist.
Right. Yeah, that's only going to exist for those who want to follow it, and we should make following the law as easy as frickin' possible.
Yes.
Especially when it comes to restricting liberty or eliminating it in some cases.
All right. But here, so if you have
just one thing, sorry, Nick,
go ahead.
Last quick point. So, application note 3 to this new guideline does speak to the court's power to extend supervised release, but it just says this: the court's ability to extend a court's authority to extend a term of supervised release. In some cases, extending a term may be more appropriate than taking other measures, such as revoking the term of supervised release. Great, I love that. But where is there any guidance? Hello, guidelines. Hello, commission. Where is there any guidance in here as to what a court should consider when extending terms of supervised release? And the reason why I'm so worried about this is now courts may be thinking, okay, I can go easy when I first impose supervised release, but now I always have this ability to just keep on extending, in some cases indefinitely, because let's say that the statutory maximum, like it is for sex offenders and terrorism, is life. Now that individual gets out on supervised release, and with very little to no due process, with very little to no due process protection, a court can just end up just keep extending supervised release indefinitely. And there's no guidance to courts as to what to consider. The commission dropped the ball on this. I like the fact that they've addressed this, but I just see problems here.
Well, I have a question for you, and maybe, I don't know if you know the answer or not, but under the existing supervised release scheme, if you violate the terms, you are allowed a hearing, and if they prove that you violated, they don't have to prove by preponderance. There's no rules of evidence, blah blah blah. But the point is, the judge has the ability to send you back to the Bureau of Prisons, and there are there's a whole other guideline that talks about what those should be. It's either 4 to 10 months or 3 to 6 months or whatever. So if it's for a grade C violation, and depending on criminal history, this is all in Chapter 7. 7B1.4 dictates that. And my question is all that untouched? Does the court still have that discretion to send you to prison for that?
Absolutely.
They do.
Yeah.
Okay.
Yeah. All that's untouched.
Yeah. Okay.
They still have that ability.
All right. Well, so, don't let anyone snooker you into thinking you're not entitled to a hearing, because even though we're in Gilead, you still are. And Rule 32.1 of the criminal rules sets forth all that in great detail. But I do think you could probably, if you do go through violation hearings and the judge does want to resentence your client to prison, you might be able to find some help in this language that the goal of supervised release is now just separate and distinct from the goal of probation, and that this is about fulfilling rehabilitate. There's two pillars of why they made these changes under the proposed amendments. One is to give the courts greater discretion as to what they can do as far as the terms, and the second is to, quote, fulfill rehabilitative ends distinct from those of incarceration.
Yes.
And so if you're failing on supervised release and you violated and they want to give you incarceration, you should make the argument that Incarceration is not the goal here. Punishment is not the goal here.
Right.
Always, for supervised release, the goal is to fulfill rehabilitative ends. So please explain to me how sending this person back to prison, especially the BOP in its current form, is going to do anything to fulfill rehabilitative ends, because that is the main goal of this amendment. Always put that in front and center, because the status quo, what we're used to is, yeah, they did something wrong, so they have to be punished, and now they're going back to prison. And we usually don't fight that hard in
Yeah.
these hearings and take that language and use it, because it's very important. It's very important.
And just so the listeners out there are aware of what part we're talking about, it's a new subsection. It's subsection part C to chapter 7, and chapter 7 has to do with supervised release and all that, as well as revocations. New part C is about supervised release violations, and what Doug was just referencing, there's some excellent language in there in this introductory commentary
Mhm.
about how if I could, let me just read this brief part to everybody.
Yeah.
Because supervised release is intended to promote rehabilitation and ease the defendant's transition back into the community, the commission encourages courts, where possible, to consider a wide array of options to respond to non-compliant behavior and violations of the conditions of supervised release. These interim steps before revocation are intended to allow courts to address the defendant's failure to comply with court-imposed conditions and to better address the needs of the defendant while also maintaining public safety. So basically, revocation is a last resort,
Mhm.
and you cannot look at violations of terms of supervised release as so serious off the bat by default as to require reincarceration, is what the commission's saying. Look at everything else, because the point of supervised release is to transition back. It's rehabilitative. So failure to follow guidelines that are or rules that are meant to help you rehabilitate and transition back into society aren't quite the same as failure to follow the law or engage in a crime outright. That's the point.
Yeah.
And I
Yeah.
like that. And I think, and I applaud the commission on this part here. I just wish they were a little bit clearer on other places, but I could always be a critic of the guidelines. So
Yeah. Yeah. Well, it seems like a step in the right direction.
yes,
My
yes,
concern is we're so wedded toward, it's almost like when Booker happened, we were still so locked into the old scheme that it was hard to shake people off of that. And, I will be interested, it'll be interesting to see if judges take this to heart immediately and say, yeah, I don't need to give supervised release here. I don't have to. And I don't think it's warranted,
and
so
I don't necessarily, when I do, I'm not going to just by default treat a revocation, treat a violation of a term of supervised release as if it were a new offense, and
yeah,
therefore reincarcerate somebody.
right. So good, that's good stuff. Now, it should be
Yeah.
noted there were several proposed amendments. We're not going to talk about all of them because we don't want to make this podcast 3 hours long. So we're going to skip right to the big, what it
A
really
big
looks
one.
to me to be a seismic
Yes.
shift, like massive. The
Yes.
simplification of the three-step process. So what do
Yes.
they mean? Let's just start with what is the three-step process? What are they simplifying?
Okay. So the three-step process was created by Booker in essence. Booker was the case 20 years ago that said the guidelines, if you treat them as binding, that's unconstitutional. So therefore, they're merely advisory. So before that, there was a two-step process in imposing a sentence. You first apply the guidelines, figure out what that sentencing range was, and then you consider a list, a very limited list of grounds that could constitute a downward departure. There was a catch-all there, 5K 2.0, for those that remember that, where if the case was outside the heartland, that could also be considered a ground for a departure. And a departure was a sentence outside the guidelines, either above the guidelines or below, but they were intended to be rarely invoked. that, in other words, departures were to be by a very rare exception. 90% of the time, sentences would be within the guideline range, unless they were like a 5K 1.1 for cooperation or a 5K 3.1, which has to do with fast track. And we'll talk about that in a second. So that was just two steps. First the guidelines, then consider departures, and then that's your ultimate sentence. Once
Can I
Booker
ask a
came up,
question?
sure.
Though those departures, because there's this list of downward departures, which were
Yeah.
almost never given, unless
Yeah.
they were quote unquote outside the heartland or whatever. But there's a list of upward departures too. Are the guidelines, isn't the guidelines talking about both down and up
Yes.
when they're removing them?
Yes.
Okay.
Yes.
All
Yes. Yes. Yeah. Up
Because
and down.
there are a lot more up than there were down.
Yeah.
And there was seemingly no real sort of limitation on when an up, like it was upwards were always kind of fair game and fine, weren't they? It was the downwards that were the ones that should never be applied except in the most unusual, right?
Right. That's true.
Yeah.
That's true. There
Yeah.
was, yeah, the upward departures were never, what's the word, disinhibited
Yeah.
by the commission, but they were really frowned upon by the commission when they went down.
Yeah.
So at any
Okay.
rate, so once Booker comes along, now the guidelines are just advisory. So what happened is courts were still figuring out the guidelines. That's step one.
Uh-huh.
Then considering any departures, that was step two. But now, because the guidelines were advisory, they could also consider this new related ground called a variance.
Yeah.
And so you had guidelines, departures, and then variances. And a variance can be for any reason, whether it's identified in the guidelines or not, or it could even be for a reason that the guidelines said should not be considered, such as education or something along those lines.
And of course, the sort of operating statute for the variances is my favorite, 3553.
3553A.
Right.
Yeah.
And so it took 20 years, a long time after Booker, but eventually 3553 really did take center stage.
Yes.
To say no matter what these advisory guidelines say, you always have to consider these factors. The big ones are nature and circumstances of offense and the history and characteristics of the person. So these were how we got significantly. This is how we've been getting significantly below guideline sentences
correct.
For years
and that's
now.
Correct. And what a lot of courts recognized, and this is true, what's the difference between a departure and a variance? Really, at the end of the day, nothing, because you still get, it's going to be, if it's below the guidelines, it's below the guidelines. Doesn't really matter how you got there. Above the guidelines, same thing. And so courts just stopped citing departures and just said, I'm just going to vary. I'm going to vary. And by the way, a variance can also include a policy disagreement with the guidelines. Maybe you thought that the way the commission rated or weighed a particular drug was too onerous, or the way it would give you a upward adjustment for use of a computer in a child pornography case. And I love this particular example because there was a judge out in New Mexico about 10 years ago who said giving an upward adjustment for use of a computer in child pornography is like doubling somebody's fine if they're caught speeding for use of a car. Mm-hmm. So there was like these little silly adjustments where there would be just like, I don't agree with the policy of the commission for this particular type of offense, so I'm going to vary from it. There was no ground for a departure for that. So courts
I'm gonna sing your praises, because I think one of the most significant grounds for variances has basically been these guidelines are broken, they're wrecked. Yes. They're not grounded in empirical data, and this is simply too much time. Yes, and of course, exactly. The way that we start to show that is through statistics, and it's almost like that perpetual motion thing, because the more we show that other judges are giving lower sentences, the more judges start giving lower sentences, because everyone comes to recognize that these recommendations from the guidelines were kind of bullshit to begin with.
Right, and as they should, there should be this herd mentality in sentencing. That was the whole point of statistics. The guidelines were built from statistics, and the statistics and data were meant to help the commission continually revise the guidelines. And the sentencing data from all the judges out there, from all the sentences out in the field, that was meant as a feedback mechanism for the commission. And finally, now 20 years after Booker, the commission is finally adjusting the guidelines for Booker. And some out there might not be seeing this yet. So, okay, Mark, why get? And so what did they get rid of? Departures. So there's no more departures. There's really only one departure left, and that's 5K 1.1 for cooperation if you're a cooperating defendant. And there was another ground for a departure called 5K 3.1, which had to do with fast track programs. What the commission has done now is move that into the guidelines proper, so it's no longer a departure, but it's a new provision called 3F, like Frank, 1.1, and that provides for up to a 4-level downward adjustment on motion from the government.
Yeah.
In those districts that have a fast track program. And what's fast track? It mainly applies to illegal reentry defendants that we were talking about earlier. If they plead really quick, they can get even an additional, now a downward adjustment. Before it was a downward departure, a lower sentence, because the thought there was these fast track districts, there's so many of them and they're swamping the resources down there. And these people are going to be sent back anyway to their country of origin. So let's just get them through the system and get them out as quickly as possible. That's basically what the fast track was, to try to ease the burden.
So I got a question for you though now, because there's really three things that are going to be lost in these guidelines that are going to be taken away. And we've talked about upwards and downwards. So they say Chapter 5, Part H is going to be deleted. And
Correct.
these are really just a small handful of basically downward departures, mostly, right? And then Chapter 5K are the list of most of those. 5K2 are upward departures. Well, no, these are downward departures. These are
some downward, but
they're downwards too, but they're all going away. And
correct.
But then the third one is they're deleting the departure provisions currently contained in the commentary to
Correct.
other various guidelines. And I was just wondering offhand, like, what would be some examples of?
Oh, I know. I got raising my hand.
Okay, yes, sir. You in the back.
Yeah.
Well, Don't you hate the one that always wants to raise their hand and answer the question?
Yeah. In law school, we called them the gunners. I was never a gunner.
I find that hard to believe.
Oh no, yeah, no. I was trying to stay awake usually.
Mm-hmm.
This has to do with the Cameron Smith case that you and I have worked on. There is under 3A 1.4, which is the terrorism adjustment, the largest single upward adjustment in the guidelines as a whole.
Yeah.
I mean, it dwarfs everything else. It's a plus 12, and it puts you into a criminal history category 6. And if that plus 12 doesn't get you above offense level 32, you just go up to an offense level 32. So it's a base of 32 with a plus 12 and a criminal history category 6. It's huge. There is an additional upward departure provision for that guideline. So if that 3A 1.4 wasn't enough, or if 3A 1.4 didn't apply for technical reasons that I'll spare everybody, there was this other upward departure provision that
in the commentary
that said you could still depart upward as much as you want if 3A 1.4 doesn't technically apply, but you judge think it should. This guy's a terrorist anyway, so domestic or foreign or whatever, you can still upwardly depart. That's gone. Gone.
So the main guideline of 3A 1.4, which is isn't that technically an upward departure, and shouldn't that be gone?
No, that's an upward adjustment. So what's the difference between adjustments and departures? So remember the two, we had 3 steps, we had guidelines, departures, and variances. Now we're just back to just 2 steps like we were before Booker. Just now we're just guidelines and variances. That's it. It's that guideline part. That the first step, what an adjustment is like a plus 14 for the loss amount, a plus 4 for rolling the offense, a minus 3 for acceptance of responsibility. All those pluses and minuses that add up, that get you to your total offense level, those are called adjustments. Most of them are upward. A few of them are downward, like the new 4C 1.1 for the 0-point offender. That's what we would call a downward adjustment. It's an adjustment to your offense level, as opposed to a departure, as we've talked about, or a variance. And now we just talk about variances. And that's once you get that total offense level in your criminal history category, you go to the sentencing table, you see what your sentencing range is there. And now a variance is anything below or above that range.
So adjustments, would those be akin to what we would call specific offense characteristics?
Yes, that's exactly what they're called.
And so, and from a practical perspective now, great, they're excised, they're lost to the guidelines proper. They don't exist there. But what's to prevent a prosecutor from going, well, this used to be a thing, and because step 2, you must consider the nature and circumstances of the offense, you should really just consider that thing that used to be a thing over here instead of in the guidelines. Put it under 3553.
Under 3553, a court can consider whatever it wants to. But let's just use the terrorism, the upward departure for terrorism that no longer exists as of, or won't any longer exist as of November 1. Again, these are just proposed amendments. Congress has to sit on them for 6 months. But at any rate, so if the government were to raise that now and say, well, look, it used to be a thing, you could still do it, Judge. Yes, Judge, you could still do it, but Judge, you need to take into consideration that the commission expressly deleted that. So that it's no longer what's called an encouraged ground for an upward departure. As a matter of fact, there are none anymore. There are no encouraged grounds for upward departures or downward departures other than 5K 1.1. Judge, it's up to you. Now, this is where I think it's the earth shaking, and this is where there's a good segue now into why this is so significant. Big deal. They got rid of departures and they replaced them with variances. Those two things were a distinction without a difference, Mark, and they made all these other changes. Got rid of all these other departures, but a prosecutor could still cite them. Right? So what's the difference? Well, how is this earth shattering? It's the reason why they did this. Yes, to simplify, but it's much more than that. And I would just ask you if you could indulge me just a few minutes, or for 2 minutes. I'd like to read the language that the commission has used to change Chapter 1. And Chapter 1 is the whole, if you will, philosophy behind the guidelines. And by I'm using philosophy with a lowercase p, not a big P, because there is a philosophy there. I don't want to go down the whole rabbit hole about whether the guidelines have a philosophy or not. But this is like basically what Chapter 1 does is identify kind of the rationale behind the guidelines and what they're intended to. So this was under the authority provision under Chapter 1, and it states that the United States Sentencing Commission, independent agency in the judicial branch, Congress directed the commission to establish sentencing policies and practices for the federal criminal justice system. And now what they deleted the following language: that will assure the ends of justice by promulgating detailed guidelines prescribing the appropriate sentences for offenders convicted of federal crimes. Commission deleted that. And instead, they put in and develop guidelines that further the purposes of sentencing. So what are the purposes of sentencing? The purposes of sentencing are articulated and set forth at 3553A. Okay? And what 3553A says, it's directed not to the commission, but to sentencing courts, to the actual judges. And it states that a sentencing court shall impose a sentence sufficient but not greater than necessary quote unquote, the parsimony principle, to
Mm-hmm.
comply with the purposes of sentencing to reflect the seriousness of the offense, to promote respect for the law, to provide just punishment, deterrence, protection of the public from further crimes, and rehabilitation. So now where are you going with this? Now, this is it. What I'm going to read to you is now in the guidelines, and it is the rationale for why they got rid of departures. And it really has nothing to do with quote unquote simplifying. The requirements and limitations imposed upon the commission by 28 USC 994, that's a statute. Congress directed the commission on how to make the guidelines, do not apply to the sentencing court. So 28 USC 994, which is the limitations on the commission, do not apply to the sentencing court. To the contrary, Congress set forth the factors that a court must consider in imposing a sentence that is sufficient but not greater than necessary to comply with the purposes of sentencing in 18 USC 3553A. I'm almost finished. These statutory factors permit a sentencing court to consider the widest
possible breadth of
information.
This is my favorite part of the whole thing. I'm so glad you're reading it. Sorry, I didn't mean to interrupt. Say it again.
Okay, to consider the widest possible breadth of information about a defendant, ensuring the court is in possession of the fullest information possible concerning the defendant's life and characteristics.
Yes, I love that.
Accordingly, I'm almost done. And I'm leaving out a bunch of citations. The commission actually cites a bunch of Supreme Court cases for this, just quoting from them. Accordingly, the application instructions set forth in the following part are structured to reflect this two-step process, whereby the sentencing court must first correctly calculate the applicable guideline range as the starting point and initial benchmark. And here it is. Drum roll.
That was the lamest drum roll
I know.
I've
I'm sorry,
ever heard
I'm sorry.
in my life. Oh my God.
That was pretty stupid, but whatever.
I'm going to just give you an A for trying. That's okay.
Well, actually, in post-production, can you put in like a little drum roll there?
Oh, yeah, absolutely I can.
Thank you, sir. Thank you. And then...
Wait, let's do this again then. Drum roll, please.
Okay, drum roll, please. Then must determine an appropriate sentence upon consideration of all the factors set forth by Congress in 18 USC 3553A.
Yeah.
So let me summarize that. This is huge. And this is the big takeaway. The commission now, for the first time, is admitting in writing in the guidelines itself that they are incomplete. The commission's hands were tied by Congress with the enabling legislation 40 years ago, when the commission was first created, when the commission cited to 28 USC 994. 994 was the enabling legislation. It was part of the Sentencing Reform Act of 1984. And what the commission now is pointing to is that constrained us. The Congress told us that we cannot consider everything we want to or need to in order for judges to achieve the purposes of sentencing. So the guidelines are incomplete. And as a result, courts must, not may, not should, but must determine an appropriate sentence upon consideration of all the factors set forth in 3553A. What does that mean? That means every single case must be considered for a variance. In fact, I would go one step further, that no sentence anymore should comply with the guidelines. There must be a variance imposed. Now, the court might accidentally, if you will, still impose the sentence within the guideline range, but it can't be based upon the guidelines alone. The court must take into all these other factors that aren't into the guidelines. What does this ultimately mean? It means that the commission now is admitting that the guidelines are junk. Yes, you have to, by law, go through this silly step of calculating the guidelines as a starting point and initial benchmark. But how much weight do you give that? Basically none,
Yeah.
because you also have to go into 3553A and consider all these other things
Yeah.
if you want to achieve the statutory purposes of sentencing, which courts are directed to do. So the only way a judge can impose a sentence that complies with 3553A is to disregard the guidelines and then just go with their gut, so to speak. But there's more than they don't need to just stick with their gut. We actually have data. There is now a common law of sentencing that's being developed through data. And that is what I've always thought is the commission's the best aspect of the commission is its comprehensive data collection and analyses and output. I can still criticize some of the reports that they put out, but it's that data now that courts must, in my opinion, refer to because one of the provisions of 3553A is to avoid unwarranted
sentencing. Yeah.
So that's the only way to achieve this. Forget the guidelines. You look to what other similarly situated people are, how they're being sentenced, and that's the only way to do it. And how do you define other similarly situated individuals? Well, this is where the calculating the guidelines does help because now you can find other people sentenced under 2B 1.1 with a total offense level of 35 in criminal history 2 with 4 criminal history points, something like that. You can get that detailed, and maybe they're over 50, or they have a college education or just a high school education. You get all that stuff, and that's what you can use to advocate for your client and say, look, judge, yes, start with the guidelines, but not for purposes of imposing a sentence, finding that range. You start with the guidelines now for purposes of identifying similarly situated individuals. And that's where the data and everything comes into place. I actually wrote a law review article in Federal Sentencing Reporter about this about, I think, 5 or 6 years ago.
Oh, well, send it to me and I'll put a link in the show notes so people can have that. But, I love how enthusiastic you are about this, and I share your enthusiasm. But one of the things that we're glossing over in terms of the recognition, the implicit recognition that the guidelines are junk. If I was going to fully celebrate, I still think I'd be fully celebrating the death of the guidelines entirely, because even when you talk about this initial starting point and initial benchmark, you have to take into consideration that the things that are still there that weren't lost are junk too, because they're so wildly pulled out of thin air. There's no empirical, these massive loss amounts that put people up to even the things that we're looking at for the starting point and initial benchmark are more often than not so deeply flawed and broken and nonsensical and arbitrary.
Use of a computer in child pornography cases.
Yeah, it's still there.
Which even the Department of Justice is on record saying is junk.
So I think the practice pointer is that's great. But just make sure when you say, yeah, judge, guess what? This says this is our starting point, but here's why even that's junk. So really what we're needing you to do is just forget these guidelines. Forget them, because they are not worth the paper they're printed on.
Correct.
But the vindication for me, and my favorite part and why I share your enthusiasm, is because for the last 2, and I don't know how many years we've been doing this podcast now, I always start out by saying, coming to you from Studio 3553. And the reason is because that has been, the beating heart and soul of this practice, to say, forget the guidelines. 3553 is everything. And for them to now say, the court must consider the widest possible breadth of information about a defendant, ensuring that the court is in possession of the fullest information possible concerning the defendant's life and characteristics. That's all the soft stuff that everyone, good-naturedly pokes at me for. But the soft stuff is the beating heart of what we're doing. And it says, judge, these are human beings, and you have to have every single piece of information about this person's life in order to make a fair determination about what their sentence should be. And now it's just there in big, bold, black and white letters. And I just feel, I don't know, vindicated or happy, and I'm optimistic, and I just want any practitioner to know that it has been your job to put that front and center. But if there's any,
Yes.
in case there's any doubt, now it should be gone. It's absolutely gone. That these are
Yes.
massive changes, and the hope now is that we start to see some massively, different sentencing outcomes as a
Yes.
result of those.
Yeah. And
So.
I wanted to add one quick thing to this. One of the things, though, there are the commission says our hands were tied by Congress, and so that's why when we created the guidelines, and when we still amend them because Congress hasn't changed the law. 994, there all the restrictions and stuff in there are still there. So there are things in the guidelines that we commission think should be in there, but we can't. I want to add this, though, and it's very important for everybody to understand. There are things in the goddamn Sentencing Reform Act that were directed to the commission 40 years ago to take into consideration when it promulgated the fucking guidelines that it still has not done. And the biggest one of those are taking into consideration the Bureau of Prisons, the capacity of the Bureau of Prisons. Still, with all this stuff that the commission has done, and I applaud them, they're going about it in an okay way. I give them a B minus. But the big, big, big problem that has been staring the commission in the face for the last 40 years is that there's nowhere to put all these people.
Mm-hmm.
The Bureau of Prisons is consistently been over capacity with some institutions 200% over the rated capacity.
Yeah.
Right now, as of last week, there's 181 active federal institutions. Over 90 of them are at 100% or more of their rated capacity. The commission has been silent on all of this stuff. The commission has never taken that into consideration. And that is something that the commission shamefully has had 40 years to do. And I'll just as an example of this, 2 years ago, the commission finally addressed another provision of the Sentencing Reform Act that Congress directed them to take into consideration. And that had to do with first-time offenders, with those that had no criminal history. Congress told the commission when creating the guidelines to ensure, basically, anybody that was a first-time offender and didn't commit a violent offense or an otherwise serious offense, that find an alternative to them than prison.
Yeah.
That has always been part of the core legislative one of the core legislative directives to the commission. It ignored it for 38 years. 2 years ago, finally, we get 4C 1.1, the 0-point offender, which is an imperfect, as everything's going to be. It was an imperfect recognition, finally, that the commission needed to do something about this, and they did. And I applaud the commission for that. Gives you a 2-level downward adjustment. If you have 0 criminal history points and you meet a bunch of other criteria, some of which I disagree with, like the role in the offense, that shouldn't be part of it. Commission kind of added that, or as an exclusionary factor. At any rate, it took them 38 years to do that. It took them at 40 years, they still haven't addressed this elephant in the room, which is getting worse by the day.
Yeah.
There are more facilities that are getting closed down by the Trump administration.
Yeah.
I think if I'm going to be a conspiracy theorist, it's because he wants to privatize everything for his buddies. But be that as it may, there's no room at the inn anymore. And putting in these first-time offenders that commit fraud offenses and all this other stuff is not serving any purpose and is contrary to what Congress intended.
Right.
And the commission still has yet to address that. I hope to God they do it.
It's not just overcrowded, it's overcrowded and understaffed.
Overcrowded, understaffed, mismanaged, infrastructure falling apart. It has one of the worst. It is actually rated the worst federal agency to work for consistently over the last several years, and everybody's quitting.
Right.
And they're using the cooks and the teachers as COs now because they can't. There's not enough staff.
Well, and the psychologists and the nurses
and the psychologists,
and that's called augmentation. This is not imaginary. This is all happening. And we've talked about it on many podcasts. But the reason
Yeah.
we keep talking about it is because it's inextricably tied to the sentencing, determination. And we always have to be telling the story of prison at
Yes.
sentencing. And now,
Yes.
and tying it to the guidelines.
Yes. Yes.
So, that's, the other thing, well, your conspiracy theory, and now we'll get a far field, but, about private prisons, I think is probably true. But I also just saw that and I hope this is not true, but they're considering moving the BOP under the auspices of the Department of Homeland Security.
Jesus.
And my conspiracy theory is so they could start shipping more people off to El Salvador and stuff, because
Yep.
that's all under Kristi Noem and her little cosplaying,
Yeah.
flak jacket, machine gun raiding, immigration raid shit is doing.
Yeah.
She's the one responsible, among others, for what's going on with Mr. Abrego Garcia, to bring it full circle from where we started this. And
Mhm.
heaven forbid this administration thinks, well, we have all these, felons, and I know they're citizens, but why should we have to manage them here? Let's send all those people to El Salvador too.
Yeah, they're basically going to start stripping citizenship of anybody convicted of a felony.
I guarantee you they're thinking about that. The
Yeah.
only question is, what can you do? What can you do about it? And I don't know the answer other than yes, go out and march peacefully in the streets on
Protest and vote. That's what we've
protest and
always done.
vote.
Yep.
Unfortunately, this podcast episode drops Monday, so that'll be after
Yeah.
the next hands-off protest. But they're going to
There'll
keep
be
doing those.
more.
They're keep doing those. And
Yes.
yes, I would inundate your Congress people with emails and vote. Fucking vote. The
Yeah.
midterms will be along, and if there's a shift in the balance of Congress, then that'll be some other co-equal branch of government for Trump to ignore. So it'll be great.
Yeah.
And
Shit.
then, I don't know what happens after that. We'll have to see. But, I was thinking about a title for this. You said the guidelines were incomplete. You said this is a recognition that the guidelines
Yeah.
were
Incomplete and
yeah,
insufficient.
yeah.
Incomplete
But
and insufficient.
I'm thinking one
Yeah.
of my all-time favorite movies, Jerry Maguire. You complete me. This
Yeah.
is this is Jerry telling Renee Zellweger, this is his big shining moment of completion. And I think
Well,
that we
no,
have
that's the
reached,
point. They haven't been completed though.
but
No,
they still need some completion. And
they
in
need
my
a lot. Well,
opinion, the
that's
only
my point.
completion is extinction, but that's the whole nother
Yeah, well,
podcast.
but the guidelines, they're still. That's my point about my rant on prison capacity. Is they don't take prison capacity into consideration. They don't direct judges to do that. It's
Right.
which they should.
Right.
And judges generally know, as we all know, at sentencing, where I mean, a judge cannot direct the BOP where an inmate should serve his sentence, but the judge can recommend.
Yeah.
And as every attorney out there should be doing, is they should be recommending to the judge what facilities
Hmm.
that an inmate should be designated to. And so judges need to be aware of this, but where they're designating inmates to, defendants to, what's the capacity of these facilities, and counsel should be advising courts on
Yeah.
what is going on at these facilities and where
Yeah.
they're likely to be designated. I mean, it's not that much of a mystery. It's not
Right.
like it's not some random lottery where they could be. The BOP has well-known guidelines about where they're going to designate certain people,
Yeah.
and what type of facilities, security wise, what level of security, whether it's a
Hmm.
camp or a low or a medium, etc.
Yes.
And and
Yeah.
so at any rate,
Yeah. Well,
yeah.
that's
So
important
that's where the
advice.
guidelines are incomplete.
Important
So
advice. And
yeah,
we've done a million episodes on the dangerous, dysfunctional, dehumanizing Bureau of Prisons. So I'll put some
yeah,
of those links in the show notes too. You can send me your law review article for all the
yep,
nerds out there who want to geek out on some legal analysis, some crack, brilliant legal analysis by the gunner, the man
the
who
gunner,
wants to
yeah,
raise his hand and be called in class.
yeah.
Mark Allenbaugh. So I think that we have reached our completion for this podcast, but we'll be back soon to talk to you about all kinds of fun stuff. So thanks for being here, man.
Okay, well, thank you, Doug. This was great.
That's it for today, but before we go, I just wanted to take a moment and say thank you to you, the listener, for spending time with us today getting set for sentencing. Whether you're a lawyer, someone who could use the help, or maybe you're just a true crime buff who loves the inside scoop on how this whole thing works. If you're interested in knowing more about what I do, mitigation videos, case consults, live teaching, on-demand educational content, books, articles, all of it, please visit www.dougpassonlaw.com. I'm Doug Passon. Until next time, hang in there. Wait a minute, that's a stupid way to sign off on a podcast about sentencing. Hang in there. What's the matter with you, man? I guess they call that gallows humor. Sorry. All right. Well, I will see you next time on Set for Sentencing. Bye-bye.